So welcome to the last session, and we will start in reverse order. So Professor Eakeley and I will present our paper last, and due to the time difference and the recent geographical changes, I think how Jiang should start first, and he will present on the Chinese Civil Code and the related developments. How the floor is yours.
Okay, I appreciate that. Yeah, just 10 minutes past midnight, and I'm here in Milan. Thank you for having me. And without further ado, I will start my presentation, which is it's general, so it's very difficult to do, and it really covers. It's an overview of the latest enactment of the Chinese Civil Code. Each bullet point in this paper can be a separate presentation. So I'm going to pick three topics that so that I can be more focused. I think this paper proves that I went to a preliminary session yesterday, and I think the thesis is that comparative law is impossible. Basically, I think at least that's what I heard. This paper, I think, partially proves that we can do comparative law so long as we define the scope of legal transplants and the utility of comparative law and legal history can be something that's useful so long as we limit the scope, we define the scope. So without further ado, I think a few points I want to make about, there are so many things that have happened in this enactment of Chinese Civil Code, which is the first civil code in the history of the communist regime since 1949. So many things have happened, but I will make a few positive comments and a few critical comments about what has happened. The first major difference in terms of contract law is that I think now China has I think completed the principle of freedom of contract by streamlining the validity of contract rules, because it was a mess before. That is not because of the incompetence of the lawyers. It's really because of the economic structure. Let me be more specific. In the first 30 years of the communist regime, there was no wideability contract. There was no relatively now contracts. All originating factors in contract law lead to the absolute nullity of contracts because the state was the only stakeholder in contracts because of the predominant or 100% state ownership in every single contract, because of all the fact that all contracting parties back then were state-owned enterprises. And Yuliya, of all audience, you know this much better because this all goes back to the Soviet regime. With no private ownership and the less than sufficiently competitive market, it really doesn't make sense to give contractual autonomy or freedom contract to state-owned enterprises, which will only lead to the problem of stripping of state assets, because again, the only stakeholder will be the state, and without a free market, the price does not reflect the value of the commodity, and the profit does not reflect the competence of the state-owned enterprise managers. With that problem, early on in the first 30 years of the communist regime, all voidable contracts that could be vitiated by fraud or duress or mistake were all absolutely now. Until 1999, things changed a little bit because the doctrine, the principle of freedom contract was introduced, and the concept of voidable contract was introduced. but still there was a difference. There was an article in the contract law, Article 52, Section 1, that would make all the voidable contracts induced by fraud and duress absolutely null if it harms the state interest. I did some research on that. It only means that if the state-owned enterprise financial interest was harmed, the contract would be absolutely null. So that was weird. And another thing that made the law back then weird was Civil Jurisdiction Act induced by fraud and duress was absolutely null, and it was not voidable. It was absolutely null and void. But if you have experience with German law, you will know contract is a subsection of Civil Jurisdiction Acts, Heizgeschaft, Privatwillenserklärung, as German law would say. So that's really contradictory. But the main reason is they want to be more paternalistic to curb the stripping of state assets. Things changed since 2017 when they started crafting this civil code, and when they drafted the general principles, they streamlined the rules. Right now, it's just like in most Western jurisdictions, fraud and duress and other discriminating factors will only make a contract avoidable or unavoid. So that's something comparative law can do it's like a baby step that every system have to take when you introduce the private ownership, when you introduce a free market. It's easy to do. It's effective using the tool of comparative law to make the private law like private law. However, I will argue that there is a deeper problem that comparative law tools cannot solve here, because still 50% of the economy is owned by the state, and state-owned enterprises, they are not subject to market rules. There's a soft budget constraint that would limit their capacity to compete with private enterprises. And at the same time, that will help them in competing with private enterprises, while at the same time, they are subject to a policy-induced burden imposed by the state, because they can be chasing after non-profit goals. So with that two constraints, you cannot really use market to evaluate the performance of state-owned enterprises. If you really give them the contractual autonomy, freedom contract lies like what you would expect from private-owned enterprises in any Western economy, it will really lead to stripping of state assets. And I found cases through my research where Chinese courts will say that we are not going to be paternalistic. We are not going to look at whether it was stripping of state assets. Even when $3 million company was sold for 300,000, that was state-owned. The court was saying, it's freedom of contract. We are sitting on our hands. We are not going to do anything. It's market economy. But if anyone who has any experience with Soviet experience will know that that's not really a desirable outcome. So that's the limitation of legal transplants. You are doing it wrong when you cannot solve the deep economic structure problem. So that's the first problem. I don't know how much time I have left for the other problems that I wanted to discuss, but I'll be very quick. There are problems that lies within the understanding of the legal foreign legal doctrines that the system is borrowing, like the scope of rights protected under tort law. For example, the new Article 1165 subsection 1 really sounds like the French approach, unlike the German approach, where you should enumerate the rights protected by the legal system. French approach is really open-ended. It only says that if you harm other people's rights through your fault, you are liable. The German approach lists the rights they are going to protect, like life, body, health, and the property, and nothing else. It looks like Chinese law took the German approach, but took the French approach rather than German approach. But both the drafter and other leading authority have been saying the law has not changed because previously there were two tort law sections, let's say opposite things. One is one took a German approach and that lists the rights they wanted to protect. The other took a French approach and that was general. So the legislators were not sure what they were trying to do, and the judges, I interviewed 27 leading Chinese judges who were doing degree programs when I was teaching in Hong Kong, and they were saying they have no idea what it means to limit the scope of rights they want to protect under tort law. But the distinct problem really is if you don't know whether you want to protect just a list of rights or any rights, it's not you leave out a very important section of tort law. A distinct issue is whether we want to really protect or give remedy to pure economic loss, because it's not physical. If it's a physical damage, any legal system will protect that. If it's if you take the French approach, in theory, you protect even the pure economic loss without a physical damage. But Chinese judges don't know why they shouldn't protect pure economic loss, while the drafter himself said that in principle, we should not protect pure economic loss. So he took a German approach, but he also said that if causation and damage are clear, then we should give relief to pure economic loss. So that's really sounds to me like we are trying to give relief to pure economic loss so long as we can prove it. It doesn't make sense. You just have to make a decision whether you want to extend the scope of rights protected, or you just stick to the German approach that have been adopted by the system since 2007. Again, that's the easy question. You have to make a policy decision, but the deeper problem really is why do we protect pure economic loss? Why do we care whether there was a physical damage? I think in the West, there is a debate, and for Chinese law to make the best of the legal transplants, they really have to engage in this debate and understand why pure economic loss was excluded in the first place. I don't think I have time to explain the deeper theoretical question, but my understanding is it's really about risk compensation. If you want to remedy pure economic loss, I think the biggest objection is that it looks like you are imposing liability on others by engaging in highly risky and highly dangerous activities that other people will not expect you to be operating without carrying insurance. It's like you are driving a car and in your trunk there was a very expensive antique without proper protection. You're driving on the street and expecting other people to hit your car, then it looks like you're imposing a risk on the others without compensating them for bearing that risk, because hitting your car is going to be more expensive than hitting other people's cars. Again, I'm running out of time, I suppose. There are other things that, that really stick out in this new legislation, like the personality rights, which was supposed to be a distinct body of rights, a distinct body of law that is separate from tort law, but it really is not, according to my opinion, because such rights include the right to life, right to body, the right to health, the right to one's name, the right to name, the right to one's image, the right to reputation, the right to privacy. These are all the rights that across jurisdiction primarily being protected by tort law. So are you saying that Chinese law now is making personality rights in one section separate from tort law? Are you saying that this is not part of tort law if any of the essential element of torts is not satisfied and you are still going to give relief to such violation of such rights? I don't think so. But if you say that tort law elements have also need to be satisfied, if you are seeking remedy under personality rights, you are making the relief even more difficult because you have to satisfy both tort law provisions and personality rights provisions. It's considered a new innovation of Chinese civil law, but I just don't think it really works realistically. Again, I'm running out of time, so I can't dive into that. And one last point is cultural, which makes the Chinese law unique and creative in certain ways. For example, Western law Western tort law is based on commutative justice, corrective justice. If you take something away from me, you are bound to compensate that. That is commutative justice, but distributive justice is something different. Traditionally, Chinese moral philosophy really focuses on the point that when you are in a superior position, you're bound to take care of the weaker party. So that leads to a new liability called liability inequity, where the defendant does not have to be at fault. It does not have to be one of the strict liability regimes. One of the regimes strict liability protects. You can be liable so long as you have cause of damage, and yet you have the financial capacity to pay. And the other nuance is that you don't have to pay 100% of the damage. You can pay partial damage determined by the court under the court's discretion. I just don't think I have the time to dive into that either, but it's a new creation of Chinese tort law that fits the Chinese traditional moral philosophy, and yet it cannot be found in Western mainstream tort law. So that's something that I can see hope that a new civil law is being built upon China's unique culture and history, and does not entirely rely upon legal transplants. Okay, that sums up my presentation. I know it's very rough, and I'm trying to go through many points quickly. So if you have any questions, if you want me to explain anything, just ask me any questions when the time comes. Now I surrender my podium. Yeah.
Thank you very much, Hao. So Elaine Fahey of the City University of London is next, and her presentation is about the EU institutionalism. So the floor is yours, Elaine.
Great, and thank you very much, Yuliya. Can everybody hear me okay? So good evening to you all from London. It's very nice to be with you. So this paper is a book project that I'm doing about EU institutionalization. I'm doing 3 case studies, and I thought it would be very useful to speak about them in this kind of comparative context. I'm not a comparative lawyer, but I do a lot of work on European law and transnational in particular, and I think it's an extremely interesting dimension as to whether or not how European law fits into the scheme of things. So I did a book project a while ago on institutionalization beyond the state, certainly about the previous EU transatlantic relationships, and my argument would be to the effect that the European Union is a constant advocate of institutionalization. So from the International Criminal Court to the Multilateral Investment Court proposals, the UN Security Council sanctions regimes, to lots of international regulatory cooperation. There's no shortage of examples of where you can find the EU seeking in a global context to establish institutionalization. And it's constantly challenged classic IOR theory that it's easier to leave everything alone, leave the international order alone, than to be creating new institutions. So the fundamental raison d'etre of the EU has been towards being a multilateral global actor. And as we know, in current times, this is very much under strain. And the book project looks at the idea of institutionalization being a kind of a trilemma, that it's notoriously ill-defined. So many of us use it as a term of art without definition. And ultimately, though, ironically, it's really fundamental to a lot of what lawyers do, think, and say. And I use the term institutionalization to mean practices, processes, actors, top-down stabilization of policies, generally through institutions. So a very broad definition. But the case studies I'm looking at are the area of data and digital trade, and the EU's contemporary rise to being a superpower in data, particularly through its GDPR and its generation of compliance, national authorities, privacy architectures, committees, bodies, actors, oversight. The EU is very much about a huge architecture bureaucracy surrounding privacy. And I think that I say it's very interesting to look at three particular case studies: the relations with the US, relations that the EU has with Japan, and with China. Three very significant, long-standing partners of the EU, or long-standing economic interests, or just incredibly large-scale global relationships. And I'm very interested to look beyond court-centric views of EU law, the typical methodology applied to European Union law, particularly by lawyers in the EU, is to just look at the court decisions of the Court of Justice. And I think that we have quite a challenge of understanding this massive infrastructure that has grown up surrounding data in particular, without looking beyond this. So that's why it's very, very interesting for me just to hear all the debates today, to be the different panels in other ways. I've learned a huge amount. And if you don't know much about the European Union, one of the most critical things to remember is that institution building is a core part of the EU polity. It is how the EU has integrated over decades. And in the two areas that I'm looking at, data flows and digital trade, you constantly see this mode of being, of governance transferring along. The EU constantly encourages bilateral partners to institutionalize. It develops adequacy decisions. I'll explain what that means as to data flows, and it embeds bilateral partnerships with dialogues towards multilateralism. So it's a very specific mode of engagement. And I look at three areas where the EU is, as a global data actor, engaging in extremely large data flow regimes or relationships. So the EU-US Privacy Shield, which until recently was one of the world's largest data flow regimes, is a very good example. The EU-Japan Adequacy Agreement and Economic Partnership Agreement from 2018, I think, is another really good example of a huge scale safe flow data regime. And of course, EU-China relations are extremely interesting, although they're under negotiation. There's nothing agreed, but it still is a very significant actor to be considering. And EU-Japan in particular is very interesting because it forms a best practice regulatory dialogue through institutionalization. And ultimately, whatever your views are on the EU-China situation, or just generally the Sino-US tech war, the EU is a lone voice often for institutionalized cooperation, multilateralism, or certainly a very active voice in a field of cacophony. Okay, so just to put it in context, I think it's important to say that most political scientists who study the European Union, who say, when does the EU have crisis? They usually say that the EU suffers crisis when it is not sufficiently institutionalized. Without it, it is incomplete, or it's a failure. And institutionalization is often used in this form to understand European Union integration and developments. And I think what's very interesting to see in recent times is how in the past, while comparative law, particularly US lawyers, have described EU regulation of data as being a horror show of overregulation, Asian trading partners have also looked at EU provisions in digital trade chapters, electronic commerce chapters, to say the EU has excessive bureaucratization of data and institutionalization. But we've seen in recent times the global turn towards privacy renders institutionalization far less of a horror show, and lots of the debates going on in the US now as to a privacy agency or a global GDPR are very much symptomatic of this normalization of EU practice. I think what's very difficult for comparativists is to be focusing upon convergence effects, that the effects or successes or failures of institutionalization, for example, are perhaps understudied. Perhaps comparative law also mainly focuses upon EU member states rather than the European Union itself to a certain degree. And it's also quite easy to say that international relations is actually quite marginalized in comparative law. I've been quite surprised to learn about the minority of people who study international organizations as a comparative law discipline. I think it's also important to say that in recent times, the history of European law has become an enormous project, which there's a lot of funding all over Europe. Lots of researchers, doctoral level, postdoctoral level, are working on this as a very court-centric project. So studying decades of notes about court decisions, arguments made on cases, the notes of judges, a very long time ago, but ultimately always focusing upon past institution building. And I would argue that methodologically that there's a certain saturation point in revisionism that we need to be careful about. And ultimately, if you want to look forward at institutionalization, this doesn't necessarily help us so much. I think it is also important to note, or maybe useful to add, that the EU's regulatory capture of data always uses the same format that the European Union uses as a mode of governance. It always has a form of strategy, some kind of single market, some kind of space, an act, and a regulator. These are very classical regulatory tools of any legal system, but they're also very key hallmarks of how the EU engages in policy capture or regulatory capture. And this is coming out to the fore in so much of data regulation to date. So some quick examples. So the EU and US have many data flow regimes, particularly since 9/11, the passenger name records, the SWIFT agreement, but I think that the Privacy Shield is an incredibly interesting one to study. And all of the forms of transatlantic cooperation usually have some kind of joint review exercises, they have some kind of governance, they have different bodies who engage with each other, some kind of oversight committees, but ultimately it's a very similar set of regimes that the transatlantic relationship. So, irrespective of how bad the transatlantic relationship is, and right now the Trump administration has even sought to disavow the European Union. After 50, 60 years, it's probably at its worst ebb. But still, in all of this, the bureaucracy of the Privacy Shield has kept on going. I'll speak about in a moment what has happened, but there are a lot of entities involved, and most significantly, a transatlantic ombudsman has very recently been set up. However, just a few months ago during the summer, the Court of Justice in Luxembourg struck down the US Privacy Shield, and the former US ambassador to the EU, Tony Gardner, has described in his great new book out how the Privacy Shield was extremely hastily agreed after the Court of Justice struck down the previous Safe Harbor Agreement. And it's a very scattered series of letters, very much hybrid governance, a very weak form of governance, perhaps from a European perspective, but ultimately it was agreed. And the Court of Justice strikes it down and says in this landmark decision that the EU and US only really agreed weak institutionalization, and ombudsman was not sufficiently powerful, and there's lots of other important things they say about national security law. But it comes in against this backdrop now of very strong calls in the US for the breakup of big tech and for a US GDPR and a privacy agency. Even Facebook is arguing that the US should adopt the GDPR to some degree. And even at the depths of the transatlantic relationship at the moment, the lows at which it stands, just a few months ago, in the midst of the COVID pandemic beginnings, the US mission to the EU was very constructively, very thoughtfully engaging with the EU's GDPR in its 2-year review. And I think it's very important to show how the US, even with an administration very antipathetic to the EU in contrast to the past, is really affected by EU institutionalization practices. Dozens of US companies, tech companies responding, but also the US mission, and very constructively. Moving on to the example of Japan, the EU-Japan trade negotiations are, I think, a fascinating study of the development of really good practices in digital trade. And of course, there's a really weak history of EU Asian institutionalization. ASEAN itself is a very law-light regime, but the EU with Japan in its economic partnership agreement negotiations and strategic partnership agreement negotiations sought to create a huge economic area between the two very really developed economies. But ironically enough, Japan, despite being to the forefront of so much technology and so on, wanted to put data in the agreement, but the EU tried to refuse for a long time. And it created a very interesting synergy that I think has had very significant repercussions. So the EU-Japan agreement was, economic partnership agreement was agreed, but at the same time of it, an adequacy decision was agreed, the first since the introduction of the GDPR. And if you don't know much about all of these terms mean, essentially an adequacy decision is where the executive of the EU decides if another legal order is somewhat similar. And I think from a comparative law perspective, it's a really fascinating exercise. It's certainly heavily politicized with a lot of law dressed up in it. But to say that your legal order is essentially equivalent to the EU's or adequate for the purposes of its laws, and also in accordance with a Court of Justice's decision in Schrems, is the hallmark of how to get an adequacy decision and have safe flows of data. And the goal is not that a partner has to have the same legal standards as the EU, but rather to converge with their standards. And of course, there was a lot of critique of the EU-Japan adequacy decision that it was given far too quickly and just because of the major trade agreement alongside it. The Economic Partnership Agreement of 2018 has some very interesting provisions on electronic commerce, where the parties agree to actively engage in multilateralism to promote electronic commerce, but also to agree regulatory dialogues on electronic commerce in a huge variety of very key fields, for example, cybersecurity. But I think what comparative lawyers might find interesting is the emerging trend of European privacy values in Japanese case law. So we see over the last number of years, a lot of lower courts in Japan adopting European provisions or European understandings of the right to be forgotten. There is a Japanese Supreme Court decision of 2017, which rose back on the full force of this and doesn't really address the right to be forgotten as directly, and is a slightly more traditional narrative of it. But I think it's fair to say that a lot of people would agree that there's a lot of convergence emerging in this case law with European values, and given the background to all of this, making it quite an interesting step in the relationship. I thought it would be also interesting just to slip in there a little bit about the EU-Chinese relationship and how we understand the EU-China relationship emerging with respect to the rubric of institutionalization. And of course, the EU and China have launched negotiations on a comprehensive agreement on investment since 2014 with 31 rounds of negotiations, and in many areas, but digital trade and data flows are not part of those negotiations. And there was an agreement reached very recently between the EU and China on GIs, so very significant developments, given the grander scheme of the number of negotiation rounds. But what's kind of interesting is that in 2019, the cybersecurity law was adopted, incorporating a lot of GDPR concepts into Chinese law. For example, as to adequacy, relevance, not being excessive to the purposes processed. But I think scholars such as Anu Bradford, for example, in Columbia Law School, in her iconic book, The Brussels Effect, would argue that there's very much a questionable commitment of the Chinese law to EU-style privacy, generally, for example, the widespread use of facial recognition for law enforcement purposes, which would be unlawful in Europe. Now, can we say that this is the reverse Brussels effect? That is it a lack of institutions, a lack of enforcement in the Chinese context that makes this such a reverse Brussels effect? And I would say that there's a lot to, it's very difficult to make such a judgment at this point in time. And there's a lot of interesting things happening on the horizon, but it's probably also a very good example, potentially, of some convergence of concepts and a very different form of understanding of institutionalization. And we've heard from the last paper from Howe in particular about very extraordinary changes happening in the Chinese legal system in recent times, in addition to all the Belt and Road initiatives taking place, which many have said are law light, but we see to the contrary taking place in the civil law context. So overall, I argue that the EU puts a very high value upon institution building and multilateralism, and it certainly is generating a new era of institutionalization of data, but there is a question mark about for how long this will take place. Ultimately, there's a very much a global reach of the GDPR that is quite obvious. The EU has been a first mover in data globally. So many regimes are copying it or taking on board privacy much more seriously and copying other regimes. And there's a strong willingness on the part of the EU to promote institutionalization, but there's a very weak direct reception from partners, understandably. But on the other hand, convergence is a very significant way of understanding all of these developments, and the Brussels effect of the EU's strong protections in data and strong protections in digital trade ultimately would have an interesting push-pull factor. So I'm very interested in your comments, and thank you very much for listening.
Thank you, Elaine. And I believe we are next. My co-author, Professor Douglas Eakeley of Rutgers Law School, will lead us off and present the general background and the introduction into what led to our research, and I will present more factual data. So Doug, the floor is yours.
It's better to unmute before I wish everyone a good evening or a good afternoon or a good morning, wherever you happen to be located for this panel. As Yuliya mentioned, I'm going to present a few framing remarks that introduce at least part of the reasons for the empirical study that we've done on crypto asset enforcement around the world. The global, and it is a global market for crypto assets supported by distributed ledger technology, is burgeoning. With that extraordinary development of the crypto markets comes the need for regulation to promote competition, efficiency, and to protect investors. Professor John Coffey has pointed out that intensity of enforcement and securities regulation may be the factor that best distinguishes the United States from other market centers, and that higher levels of enforcement in the United States benefit US financial markets. But we believe that regulation of emerging technologically innovative capital products through enforcement risks stifling innovation and also risks driving capital and investors to other jurisdictions, particularly if the enforcement methods employed were developed for significantly different investment products at a much earlier time. Moreover, regulation by enforcement, as opposed to regulation by substantive rulemaking, assumes that pre-crypto rules are appropriate to apply to complex technological innovations, rather than proceeding ex ante with notice of rulemaking, comment period, and a cost-benefit analysis to determine their suitability, or the need for a different regulatory regime. The potential pitfalls of the United States Securities Exchange Commission's regulation by enforcement of crypto assets is perhaps best illustrated by the recent case of SEC against Telegram Group. In 2017, Telegram undertook the development of a new distributed ledger called the TON blockchain that would support a new digital currency called grams. Grams was designed to become a mass market cryptocurrency that would be more scalable, easier to use as a tender for commercial transactions, and speedier than any of the other cryptocurrencies currently on the market. If and when launched, the TON blockchain would be a self-governing system with open source code providing access to anyone wishing to build on the platform. In order to raise the funds to develop the TON blockchain, Telegram raised $1.7 billion in a global private placement that was effectuated pursuant to Regulation D for US investors and Regulation S for non-US investors of the 1933 Securities Act. Pursuant to purchase agreements with private investors, Telegram agreed to deliver grams to the investors only if the TON blockchain platform was successfully launched. Incidentally, only about 25% of the $1.7 billion in the initial private placement came from US sources, and yet you had the US regulator taking the lead in shutting it down. In October 2019, the SEC filed suit to enjoin the distribution of the yet-to-be-distributed grams to the private investors, contending that it constituted a quote-unquote public distribution of securities. The SEC and the federal court that granted the preliminary injunction took the position that the entire transaction, that is the purchase of grams not only by the private investors, but their contemplated resale on the market to others, constituted a security, constituted an investment contract under the definition of a security that the United States Supreme Court had decided in 1946. in the case of SEC against Fahey. And the definition of the court adopted for investment contract was a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. Telegram did not dispute that the purchase agreements with private investors constituted investment contracts, and it contended that it had complied with the private placement exemptions of the federal securities laws. It argued persuasively, I thought, that the potential sale of grams by the private investors after the TON blockchain became operational were sales not of securities, but of cryptocurrency, a commodity that had utility as a measure of exchange for the purchase and sale of goods and services on the TON blockchain. Telegram settled the litigation while its appeal was pending in the Second Circuit U.S. Court of Appeals. The terms of the settlement included a disgorgement of $1.2 billion and a civil penalty of $18.5 million. Truly extraordinary outcomes. SEC Commissioner Hester Peirce opposed the SEC's enforcement action against Telegram to begin with and deplored the settlement. In a July 2020 speech at Singapore Blockchain Week, she said, "Too often, regulatory objectivity gives way to other considerations that squash innovation. The regulator deems the innovation too dangerous or insufficiently beneficial and sends the innovator packing. Who did we protect in bringing this action? The initial purchasers who were accredited investors, the members of the public, many of whom are outside the United States, who would have bought the grams and used them to buy and sell goods and services on the TON blockchain, with the would-be innovators who will now take additional steps to avoid the United States." With that scene setting, let me now turn the podium over to my colleague, Professor Yuliya Guseva, who will present the results of our recent empirical study on crypto asset enforcement around the world. We completed the survey by the end of this past summer, and we're currently working on the next steps, the most important and immediate of which will be assessing the impact of enforcement on markets and innovation, not only in the United States, but around the world. So, Yuliya.
Thank you, Doug. With this in mind, let me outline what we thought about when we started the crypto enforcement survey. We know that there is the blockchain revolution in all financial markets. We also know that it did attract the attention of enforcement agencies around the globe, not just in the United States. And let me elaborate our results. In short, the United States Securities and Exchange Commission, and now the Commodity Futures Trading Commission, for sure, the SEC and the CFTC, Securities and Commodity Regulators, are #1 in terms of enforcement in the world. So not only, it's not just about a single jurisdiction in some other foreign country, it's about all of them combined. Multiple foreign jurisdictions combined do not even come close to the level of enforcement that we see from the United States commissions, both the SEC and the CFTC. As Doug mentioned, comparative research has long suggested, at least with respect to the SEC, that the US has one of the most active securities and financial law enforcement agencies in the world. And in accord with these studies, as well as the international research on enforcement, it looks like it is the trend attributable not only to the SEC and the CFTC, but also the DOJ, the Department of Justice of the United States, and other regulators. So despite an extensive network of international agreements, the United States prefers, specifically the SEC and the CFTC, both prefer to regulate through national enforcement instead of relying on international agreements, MOUs, and referring various cases to foreign regulators. Foreign jurisdictions basically left behind in terms of crypto-related enforcement. Our data, in short, called for additional research on the efficiency of regulation by enforcement per se, on the research, for the research on its effect, possible effect on financial innovations, and most importantly, on regulatory competition. Will other firms migrate from the United States to other countries? What will happen with crypto in the future as a result of this extensive national enforcement? And these are our preliminary data. You can see that the SEC is #1 in terms of enforcement actions. And look at the types of the actions. They go for court cases and in-house enforcement actions, administrative proceedings brought before SEC administrative law judges. The CFTC does the same thing, and there are as many as 8 pending cases brought by the SEC. If you look at other jurisdictions, it looks like only Canada and Australia, 2 other common law jurisdictions, had a few enforcement actions, and others, all the civil law countries, many of which are in the EU, they prefer warnings and blacklistings. A warning is usually not accompanied by a fine, but the court action or an enforcement action usually does result in a fine or disgorgement, just like the Telegram case that Doug has outlined. Now, if you look at the general trends, it appears that the bulk of enforcement actions by the SEC specifically was in the years 2018 and 2019, and has been subsiding a little bit since, while the CFTC has been bringing more enforcement actions. And these are annual trends. You can see that the international enforcement combined, once again, 14 jurisdictions. Technically, we reviewed 23 major crypto jurisdictions, but we were able to locate enforcement actions only in 14 out of the 23 jurisdictions. So in many countries, local regulators and enforcement agencies come out very forcefully stating publicly in various public speeches and opinions that they would be prosecuting fraudsters in the crypto space. However, that is not the case. Only 14 jurisdictions out of the 23 had any semblance of enforcement actions, many of which were warnings or blacklistings. And you can see this shape right here. The level of enforcement is subsiding in most jurisdictions and at a much faster rate than it is in the United States. This blue line is the SEC. So we can see that the rate is subsiding in the United States as well. And the only rising trend is the CFTC, which regulates commodities. Most cryptocurrencies are considered commodities, not securities. However, the SEC is sort of pushing the boundaries and extending the definition of security. We try to compare the parallel trends through our mini time series analysis. And it is, of course, hard to look at 2020 because of the exogenous shock of the coronavirus. However, this is what we have. In 2019, for the first 4 months, we had a severe decline in enforcement in all foreign jurisdictions, all 14 of them, while in the United States, the CFTC didn't have that many actions. Actually, they didn't have any, while the SEC was bringing more actions. In 2020, we can clearly see that the CFTC is bringing more actions, while probably other regulatory agencies were affected by the coronavirus. Now, even though the CFTC is playing catch up with what the SEC as the baseline in our study has been doing, its penalties are much lower than the penalties and disgorgement in the SEC orders. This is the total. That's a very significant number for administrative proceedings and for district court cases. The fines and disgorgement orders are humongous when it comes to the American enforcement agencies. When we looked at the composition of the cases, we thought that the SEC would come out very strongly against fraudsters. But that wasn't the case. Obviously, if you look at these green bars, these are combined cases involving fraud and various other violations of securities law. Yes, there were many fraudsters, but the purple bars right here show that many companies were simply violating some kind of registration provisions, which are exceptionally complicated, especially for crypto developers who are not very well versed in the securities law. So, the SEC and the CFTC also brought charges not only against ICO issuers, and there was a boom of ICOs, as we all remember, in 2017 and 2018. But the commissions also brought charges against crypto exchanges, crypto broker dealers, or just broker dealers dealing in crypto securities, etc. So the business models varied, although many cases were ICO related. Now, if we look at how the CFTC is catching up, clearly we see an increase in actions vis-a-vis the SEC. However, if we compare the two agencies, the penalties in disgorgements in SEC actions are much higher. They remain much higher. And these data exclude the Telegram case, which resulted in the $1.2 billion disgorgement order that Doug has just discussed. So we started thinking about the explanations. What can be happening here? We can think about the size of the United States crypto market, but it's not the full explanation because the United States in the crypto industry is not more than about 30% of issuances in the case of ICOs or other forms of raising crypto capital. When it comes to DeFi, decentralized finance, the United States is no longer a leader. Many companies have moved to Asia or the European Union. And so another explanation could be that old case from 1946, Huawei specifically. Maybe it's so broad that it enables the SEC to expand its authority over all sorts of cryptocurrencies. And we all know that the SEC has traditionally been considered one of the most enforcement-centric capital market agencies, in the world. Finally, it is possible that for other forms of cryptocurrencies like commodities, once again, they can be securities, they can be commodities, or they can be something else. So maybe for commodities, maybe they're less amenable to fraud. It's really hard to tell. But why are the foreign jurisdictions not prosecuting fraudsters as forcefully as the SEC and the CFTC do? So we thought about several explanations for this light touch approach. The first one could it be regulatory competition? Are foreign jurisdictions trying to purposely attract foreign firms instead of deterring them through excessive enforcement? This is obviously from institutionalism and public choice theories. Another one could be another explanation that foreign jurisdictions are piggybacking on what the US does and on the US enforcement efforts. So the SEC takes the lead and roots out fraud. Maybe that is the case. And finally, we thought about the fourth explanation, which is the extraterritoriality doctrine. In the United States, the SEC has been given very extensive authority, first by case law and then by the Dodd-Frank Act, to pursue fraudsters in cases when fraud occurs on US soil or it has effect on US investors. So these are possible explanations, but still we cannot answer, at least at this point in our research, what will be the effect on innovation? Specifically on innovation in certain countries. Will there be an outflow of entrepreneurs from the United States? And is there regulatory competition or regulatory arbitrage associated with excessive enforcement? Thank you. And let me stop sharing. So let's move on to the Q&A. Any questions for How, Elaine, Doug, and myself? And you can raise your hands in the It's right under the participants list. You can do it there. So invite, mute me, and raise hand. You can also ask questions in the public chat if you like, and I will read them out. I do have a couple of questions for both Elaine and Hal, but I didn't want to kind of monopolize the time. So perhaps someone else?
Yuliya, you have a question, a hand up.
Sure, go ahead.
Hi, I'm just would like to ask you if what recommendations can we use as compare different legal systems? Is there a strategy that you use? Like which categories do you recommend me to use in my own investigation? Thank you very much.
Who's this question for?
Maybe Haojing or Elaine. Thank you.
I think, Elaine, would you like to go first?
I'll let you go first.
Yes, comparative law is, I'm a comparative private lawyer and that's all I do. So as far as methodology goes, really there are private law methodologies, there are comparative law methodologies, and there are many. But I'm a functionalist. So what I do is, perhaps I'm biased. I think comparative law is useful because there are things comparative law can do. And in continental Europe, you can't avoid using comparative law. Again, I'm directing my comments to the ones made in the first session yesterday. I do think comparative law has its utilities. You just, we're not always comparing oranges to apples because as a functionalist who teaches doctrines, I understand that each system has to deal with certain problems, and each system, as far as private law goes, as far as contract horse property goes, you have to deal with such doctrines such as fraud, duress, a mistake, offer and acceptance, pre-contractual liabilities, remedies, scope of rights protected, liability basis in tort law, things like this. Every system has to deal with that, and we have doctrines to deal with things, and they serve the same purpose. As far as these things go, I think comparative law is very useful, and my approach is really to look at the functions they serve. As far as that goes, as far as I'm not making an overarching claims about legal systems, I think comparative law is useful, and all you have to do is really sometimes, for example, when I was talking about the scope of rights protected under Chinese law, there are easy things comparative law can do. For example, you just have to make a decision whether you want to protect every rights you can think of, constitutional rights, private law rights, any private law rights, or you just want to protect, for example, like German law, Article 823, Section 1, rights to your body, your life, your health, your property. It's a policy decision that's easy. Or you want to side with French law, it's fine. But there is a deeper level of question you have to answer, like what does the difference really do? Why do we limit the rights protected under legal system? And my answer is it's really about risk compensation, and that is really theoretical, and that is not necessarily a comparative law question. If you can answer that deeper question, perhaps it's applicable to our legal system. There are more difficult questions like the ones that touches upon the cultures of a legal system, like whether we should use commutative justice or distributive justice, or whether how do we deal with a system that is fundamentally different economically. For example, when it comes to legal transplants, Western civil codes don't deal with predominantly state-owned enterprises as we do in China. So you have to limit your expectation. You have to really think about what is beyond the comparative law techniques, the limitations of legal transplants. So again, my advice is to be careful and to know your limitations, and also understand there are things that can be done by comparative law methodology. And again, I don't claim that I'm a generalist. I do doctrinal studies. I am a functionalist.
Elaine, any comments?
Just very briefly, I mean, I study international relations and global governance, and I'm studying the key trading partners of the European Union. So I'm not a specialist comparativist, if that makes sense, but I would certainly encourage a lot of people to use the European Union as a comparative law example. There's literally no field of law that it doesn't actually regulate. And you know, even irrespective of the kind of competences of the EU relative to its member states, it's a fascinating thing for people to study from a comparative law perspective, and you will get a lot of value bang for your buck in terms of you know of what to do. So I think in terms of the data that's collected, the agencies of the EU, the institutions collect so much information that make it very easy for, I think, comparative studies. There's lots of annual reports on compliance enforcement in the member states. So just purely from an empirical perspective, you know, not having to get expensive research funding, you can have a lot of the work done for you and use the material. So I certainly would advocate that if that is a useful answer to the question. But perhaps Douglas and Yuliya have more experience to offer.
No, I actually second everything you've said, and I'm just looking at a very active public chat between Athena and How, discussing the choice of law clauses in contracts between foreign companies and public companies in China. And I think it's a good segue to a few questions I wanted to ask How specifically. So what was liability and equity? You said that it was a developing area in Chinese law, but equity is, and also you said that China follows in the footsteps of France in certain respects. So liability and equity sounds like a very common law concept. How does it correlate with the French civil law concepts, and most importantly, with those state interests which may override the validity of contracts? How does it work? So many pieces in this puzzle.
Right. I think that's separate issues. Let me first explain. I just didn't have the time, but let me explain what is liability and equity. Actually, it came from I can trace it back to the 1920s Soviet civil law, where it was used differently. When the court saw the state interest was deprived by the private parties through fraud or no fraud, they just don't think the transaction was to the benefit of the state, then the Soviet court would say, I don't think I remember the exact wording, not at 1:13 a.m., but they use a similar doctrine to say you don't need to be at fault, then you are liable. You are liable to the state. So, at its origin, it was directed at private parties dealing with the state and on enterprises' state interest. But in trans tort law, it has nothing to do with the state interest. It was entirely a private tort law issue, where one party has financial resources to compensate the weaker party, even though he was not at fault. And it came from a famous case that was decided in 2007, when one old lady was trying to get on a bus, and the young middle-aged folk was trying to get off the bus, along with 100 other people. It happened in Nanjing, a 10 million, 15 million people city in the downtown area, I was still in law school back then. So what happened was it was a collision between the two, and the old lady fell. Then the guy who hit the old lady was saying to the court in the second session, which he never alleged before, that he never actually hit the old lady. He was just trying to help. He helped her up and took her to the hospital, and yet she was blaming him. And that was against the Chinese traditional value. Somebody was trying to be a good Samaritan, and yet you are threatening him. It was a very good news story. And the judge was only saying there was no evidence suggesting the defendant was at fault, yet the defendant has the financial resources to pay. And by looking at the evidence, it's more likely than not, he caused the fall of the old lady, so he had to pay 50% of the damage, and that really triggered the public anger in China. And yet, the liability in equity was there to provide such a function when you have a loss that cannot be compensated under Western law, but in Chinese law, if you are able to pay a portion of the damage, the court will let you do that, will force you to do that, which can be traced back to the Confucius idea that I can quote, the head of state or family should not be concerned about the poverty as much as they should be concerned about uneven distribution of wealth. And there's no poverty with even distribution of wealth. So the idea was, if you can even the damage, it doesn't matter who is at fault, everybody is happier than the other way around. So that was the Chinese culture, Chinese tradition reflected in this doctrine.
Thank you, Harold.
And yeah.
Elaine, I believe your hand is raised. You have a question?
Yeah, sorry. Yeah, I just a quick question for her. I was really fascinated by like the you know, the developments of the Belt and Road Initiative, which is an extraordinary law light, institution light, and then in the background you have this, you know, it's a tremendous story that you tell, the development of this code, which will likely have profound effects, I would have thought, upon the Chinese legal system. So many businesses are understood to have, you know, the uncertainty that prevails, and then, you know, the extension of the Belt and Road Initiative all over the world, and exporting Chinese norms and values, but not their legal system. So what do you think is the relationship between the internal and the external? Do you have any specific view on that, and you know, what is the significance, or if any? And just a really quick question to Yuliya and Douglas. I was just really interested in your case selection of, because it's a fascinating story you tell, just the case selection of the countries, and, you know, kind of the particularly the European ones, which is fascinating me, but what criteria were used to shortlist them.
How?
Yes, I think it's a bit of a general question, so my comment is going to be general. I don't know how useful it's going to be, but my experience has been that I've been telling my Western colleagues, I do have concerns as to the difficulties of building a Chinese kind of civil law, and I have concerns about the effectiveness of the legal transplant. That being said, because of the economic structure, because of the state interest, that being said, I think generally, my concern is really on the other side. I'm afraid of the stripping of state assets, because judges are really Western trained. I have taught Chinese judges sent by the Chinese Supreme Court to Hong Kong when I was teaching in Hong Kong. They were studying common law, and they were studying comparative law courses taught by me, who knows European law and American law. So they are really trying to make judges, train judges the way Western judges will be trained. But my understanding is their training will prevent them from doing a good job protecting the state interest, because in the economy, simply because really, like the example I provided, applying a freedom of contract as in the West is going to cause problems in China because of this less than sufficiently free market when it comes to state-owned enterprises. But by and large, when I think most foreign companies are going to be dealing with private parties in China. And if you look at Chinese Civil Code and other relevant commercial laws, they're not that different from the Western counterparts. So I'm less worried about the certainty of the law and the certainty of the adjudication process. And another general comment is IP theft was one of the most constant complaints from my Western colleagues. But I have Hong Kong colleagues who have done empirical studies, and they've been saying, I didn't do a study, but I heard the figures. Over 90% of such cases are won by foreign parties when they're showing Chinese parties were IP theft. So that's telling. So my concern is on the other side, just it's a reverse concern about the protection of Chinese state-owned enterprises' interest. And I don't think legal transplant itself is going to solve this deep concerning economic structure problem. And I don't have an answer as to how to approach that. Yeah. Sorry.
Elaine, to answer your question, we selected the jurisdictions carefully. We looked at the enforcement actions in multiple jurisdictions, but before we even started selecting, we focused on who made public statements, where the major crypto activity was happening at the time, and then we zeroed in on those jurisdictions specifically. And as I mentioned before, there were 23 of those, but only 14 had some semblance of enforcement. So Kenya had just one warning, for example. And I believe Athena's hand is up. Athena?
Thank you. I have a question for Professor Fahey. You talked about the multilateral agreements between EU on trade and economic relations, EU, Japan, EU, Canada. We had two, EU and China. Do you think that in these agreements, the choice as last judicial resort of the European Court of Justice to interpret these agreements would be a good choice, or the other ways they were discussed in the negotiations among Canada and EU about establishment of other courts or arbitration would be a better choice? Thank you.
That's a really interesting question. I haven't really been working so much on this. I mean, I think that like it seems to be the case that the dispute settlement doesn't seem to put a huge amount towards the Court of Justice with partners. We see this also in the Brexit negotiations, right? Every effort to kind of remove the semblance of controversy from the highest court. So from my reading of it, you know, the dispute settlement side of things generally, the Court of Justice, it gets to the dispute in other ways, basically, is how I would interpret it. Like the Schrems decision, you know, it makes its mark very dramatically in other contexts, not necessarily in that actual agreement. So, for example, you know, the Schrems decision, all the Schrems decisions are good examples of this, but the workability of its judgments, the enforceability now is really questionable. So I think it may be interesting to see, for example, if there is a UK, EU, Brexit, new trading relationship and so on, like they have made a huge point of saying, keep away the Court of Justice. We do not want this type of settlement. This is infringing our sovereignty and so on. So it'll be interesting to see how that pans out. But yeah, in short, I don't think the text itself matters as much as what is going on in the background, basically, at the moment.
Elaine, may I ask you a question? Since we still have a few minutes left. I remember that a couple of times in the wake of the financial crisis. And remember, there was a slew of various statutes enacted on both sides of the pond. And I spoke with a few people from pretty big American companies, mostly in the financial industry and capital markets. And almost all of them uniformly said, I was criticizing certain SEC initiatives and what our Congress was working on. But almost all of them said that because the EU already had certain standards in place, they were actually lobbying for similar standards in the United States. To which extent did you see this effect, the lobbying effect technically, and the industry-driven effect leading to international, formal international agreements with the EU?
Yeah, that's a really interesting question. There's a lot of political scientists, I think, who do a huge amount of empirical work in this increasingly about lobbyists, transnational lobbyists, also political economy scholars. There's Alistair Young and Georgia Tech does fantastic work on this, on how like the transatlantic alliances of lobbyists now are extremely powerful and agree on things, and they want singular laws. I think financial services is a very different case to a lot of things, as far as I understand, and the push of New York and the pull of London, and what everything else in between has been very different. Like the Brussels effect, I think that Bradford describes. I'm not so sure it really gets into financial services, so it depends on kind of the area of law. I think this derivatives is a very different story to it than and so on. But yeah, increasingly, the power of, I think, the Trump administration, particularly in taxation issues, trying to bring back supply chains, has really put also a span in the works in terms of the lobbying and multinationals. But when it comes to the tech side of things, the tech lobbying has been extraordinary, of to have European standards become American standards, and that is a very consistent narrative. But I think it certainly is very different from industry to industry, and I don't know enough about financial services, but I understand the choice of law in New York law and so on. These are all very vibrantly disputed things, but they're not the same. But ultimately, the transatlantic lobbying, I think, is very well done in Tony Gardner's book as well, about and working with administrations and working against them. There's just this is incredibly actually in the EU now, there's a huge amount of US law firms that have an entire really big sections of lawyers working on lobbying in European Union law. So the dimensions of which it's going either way, it's become really institutionalized. You can actually have a career as a lawyer working in Brussels, a US trained lawyer. Tell your students this is like the future, and then they make vast amounts of money, and they have a very interesting job. They look at lots of areas of law. So that is essentially how big it's become, how institutionalized.
Thank you. We still have a couple of minutes left. Any other questions? All right, then I would like to thank all the panelists and participants and wish you good night to many of you. Thank you.
Good night. All right. Ciao. Bye.